Very, very different encounters.
Jefferson County, County Code at Law number 2 is now in session. The court is in session in cause number 23 CCCR 1782, case to style of State of Texas versus Dantario L. Bryant. Mr. Bryant, is that your full name? Okay. Mr. Bryant is present with his attorney. His attorney is Joel Vasquez. And Mr. Vasquez, you have requested that the court conduct an informal inquiry in this case. Is that correct?
Yeah, sure.
And the court will conduct an informal inquiry pursuant to Article 46B, Part 004 of the Texas Code of Criminal Procedure. The court will be conducting this informal inquiry because there's a suggestion that the defendant may be incompetent to stand trial. And the court will be conducting this formal inquiry to see if there's some evidence from any source that would support a finding that the defendant may be incompetent to stand trial. Mr. Vasquez, pursuant to Article 1.24 of the Texas Code of Criminal Procedure, the proceedings and trials in all courts shall be public. However, pursuant to the case of Lilly versus State 365-321, the right to a public trial is not absolute and may be outweighed by other competing interests, such as the interest in security, preventing the closure of non-public information, or ensuring that the defendant receive a fair trial. Mr. Vasquez, are you requesting that this proceeding be closed to the public to prevent the disclosure of non-public information?
Yeah, sure.
The court finds that the party seeking the closure of the hearing has advanced an overriding interest that is likely to be prejudiced to Mr. Dantario Bryant.
What are you saying?
The closure is no broader than necessary to protect that interest. The court have considered reasonable alternatives to closing the proceeding, and the court makes these findings are adequate. At this time, the hearing will be closed to the general public. Now,